termination of the contract of apprenticeship. The Flourence Labour Law Judge rejected the request for a declaration of nullity, illegitimacy, ineffectiveness of the termination of the apprenticeship contract inter partes put forward by a worker. The court didn't find formal defects nor contractual breaches which justified the transformation of the relationship of one of apprenticeship to ordinary permanent employment. This was a professionalising apprenticeship contract that fell under the discipline of Article 41, Legislative Decree 81-20151, to which the collective contractual regulation of the sector must be added. The contract judged was a permanent contract for the purpose of training and employment of young people, which must be stipulated in writing as evidence and must contain, in summary form, the individual training plan also defined on the basis of modules and forms established by the collective contract. It has a minimum duration of not less than 6 months and places on the two parties of the relationship a series of obligations. Among these, the most important is the obligation of the employer to provide the apprentice with training so that they can acquire the professional skills necessary for carrying out job tasks. According to the consolidated orientation of the jurisprudence, the apprenticeship contract qualifies as a mixed cause contract characterised by, in addition to the carrying out of the work performance, the employer's obligation to provide training. This obligation must guarantee effective professional training aimed at the acquisition, by the apprentice, of a professional qualification, which can be fulfilled by carrying out training activities, not necessarily administered directly by the trainer, provided that the latter is always the person to whom the apprentice must refer to the assessment of the skills acquired. What is relevant is the real and effective implementation of a training activity in favour of the apprentice who, in the case in question, was found to have been given. From a formal aspect, the law identifies the minimum duration of the contract of apprenticeship and the correct classification of the apprentice who, in this case, is correct, but which in any case could not determine the nullity of the apprenticeship contract. Maria Paola Rovetta and Federico Manfredi, lawyers.